Hello friends, welcome back to series of lectures. This is the 57th lecture of this series of Indian Evidence Act. Now let's start with section 154. Section 154 talks about the hostile witness. Now suppose the prosecution witness got the witness PW. Suppose the prosecution has got the witness PW. Now that witness has to give the evidence in favor of the prosecution. जिस witness को आप लेकर आओगे वो आपके behalf पे ही तो evidence देगा. If this witness in the court refuses to give evidence, he says that no, I will not give the evidence, or he start giving evidence. He start giving evidence in favor of the defense. Either he refuses to give evidence or he starts giving evidence in favor of the defense. Then you will say that the witness become hostile. If similarly the defense has got the witness DW and that witness is here to give evidence in favor of the defense. Now he is here to say something but he does not give any complete evidence, or he starts to give evidence in favor of the prosecution, then that witness also has become hostile. अब अगर hostile witness हो जाए तो उसके लिए what is the proceeding that 154 is talking about. तो इसको पढ़िएगा. The court may in its discretion permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. The court may in its discretion permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. So language is the same. What they are saying is, suppose PW is brought by the prosecution into the court. Now the court may permit the prosecution to put such questions to PW which would have been asked by the adverse party. जो सवाल डिफेंस पूछ सकता था वही सवाल पूछने का परमिशन प्रोसिक्यूशन को मिल सकता है. Now what does that mean? What can the defense ask? If you remember, the defense can go for 145, the defense can go for 146, and then 148, etc. So means these questions can be asked by the prosecution to the witness. Means the question which a defense can ask, the same question can be allowed to the prosecution. Same question is allowed to the prosecution to ask its own witness. The same question can be allowed by the court to the prosecution to ask to its own witness. Now why should the prosecution ask these questions to its own witness? Because the witness has become hostile. देखो आप अपने विटनेस को लेकर आओगे तो आप अपने फेवर में सवाल पूछोगे. आप उस विटनेस के क्रेडिट को इम्पीच करने वाले सवाल, या फिर उसके वेरासिटी को टेस्ट करने वाले सवाल, या फिर उसको किसी स्टेटमेंट के बेसिस पर कॉन्ट्राडिक्ट करने वाले सवाल या क्रॉस एग्जामिन करने वाले सवाल अपने ही विटनेस से आप क्यों पूछोगे? तो ऑब्वियसली योर विटनेस टर्न्स हॉस्टाइल, देयरफॉर यू आर आस्किंग सच क्वेश्चंस. सो रीड इट अगेन. अब देखो इसमें दे आर नॉट यूजिंग द वर्ड हॉस्टाइल. रीड इट. द कोर्ट में इन इट्स डिस्क्रिशन permit the person who calls a witness. So that can be the defense or that can be the prosecution, because they are saying permit the person who calls the witness to put any question to him which might be put in cross examination by the adverse party. Now again I am explaining that with respect to defense. Suppose defense get a witness DW. Now to this witness the defense supposed to be examination in chief examination तो करेगा उसका defense. Now in examination in chief, defense will ask the questions which support the defense. In examination in chief, defense will ask the questions which will support the defense, but that the defense puts the application into the court under section 154, so it can be oral application also, and seeks the permission from the court that let me ask him questions which the prosecution could have asked. Now the prosecution can ask questions pertaining to 145, 146, etc. for the purpose of impeaching of the credit of the witness and all. So those questions, if the defense want to ask to his own witness, so obviously the defense want to impeach the credit of his own witness. It may go on to injure the character of the witness by asking these questions. It may ask proper questions in section 148. It may ask questions to check the veracity of the witness, means contradicting his own witness. So that will happen only when the witness become hostile. That will happen only when the witness become hostile. So is that fine? फिर से पढ़िए. The court may in its discretion permit the person who calls a witness to put any question to him which might be put in cross-examination by the adverse party. Now I am asking you a question that why are they not writing like this? The court may in its discretion permit the person who calls a witness to cross-examine his witness. Why are they not writing permit the party to cross-examination his witness? तो ये cross-examination word क्यों नहीं लिख रहे directly? So you see that the definition of the cross-examination clearly says that it has to be done by the adverse party. अगर अब ये लिख देते हैं यहाँ पर कि आप अपने ही witness का cross-examination कर सकते हो, then in that case the definition of the cross-examination has been violated, because cross-examination is always done by the adverse party. So they are saying the same thing, but they are not using the word cross-examination. That is the same thing that you can ask the same question which the opposite party would have asked in the cross-examination, but they are not saying that you can cross-examine your own witness. They are not saying that you can cross-examine your own witness because the definition would have got violated. तो ये समझ में आ गया? अब देखो, if I called a witness तो उसका मैं एग्जामिनेशन इन चीफ करूँगा. तो क्रॉस एग्जामिनेशन का डेफिनेशन पढ़ लीजिएगा आप, सेक्शन 137. उसमें क्लियर है दैट द क्रॉस एग्जामिनेशन विल बी डन बाय द एडवर्स पार्टी. अब मैं अपना विटनेस लेकर आता हूँ और मेरा विटनेस हॉस्टाइल हो गया, तो मैं अपने विटनेस का क्रॉस एग्जामिनेशन नहीं कर सकता. एंड द रीजन बीइंग that will violate the definition of the cross examination, because the party who gets the witness, he cannot do the cross examination of his own witness. Cross examination is always done by the opposite party, and therefore when you go for the cross examination, that will be done by the opposite party. So they could not have written the word cross examination here, because that would have violated the definition of word cross examination. Therefore they are saying the same thing, but the language is different. You can ask the same questions which the opposite party could ask here to the witness, which the opposite party could have asked here to the witness. You can ask the same question. तो इसको लिख लीजिएगा आप, write down. When a witness turns hostile, the party who brought the witness may seek permission from the court to ask the same questions to the witness which the opposite party would have asked in his cross-examination, which the opposite party would have asked in its cross-examination. It is not provided that the party can cross-examine its own witness, as that would have been a violation of the definition of cross-examination, as cross-examination can be technically done only by the adverse party. अब ये एक पॉइंट हो गया आपका, that is why are they not use the word cross-examination. Now the other point is, so what is meant by hostile witness? Which witness will be considered to be hostile? वो भी समझा दिया मैंने आपको, उसको भी लिख लो आप, वन पैराग्राफ, राइट डाउन. सो राइट, what is meant by hostile witness? A witness will be said to have turned hostile if in the court he does not support the party which has called him. A witness will be said to have turned hostile if in the court he does not support the party which has called him. That is, he does not give evidence in favor of the party who called him, or he gives evidence in support of the opposite party. Next sentence. The intent and the circumstances has to be examined before declaring a witness to be hostile. The court has to see whether the witness is deliberately not supporting the party who called him. Court has to see whether the witness is deliberately not supporting the party who called him, comma, mere minor inconsistencies, that is important. Mere minor inconsistencies in the statement of the witness will not convert him into a hostile witness. Mere minor inconsistencies in the statement of witness will not convert him into a hostile witness. तो ये बहुत इम्पोर्टेंट पॉइंट है कि अगर आपका विटनेस हॉस्टाइल नहीं हुआ है तो फिर कोर्ट आपको 154 में परमिशन नहीं देगी. तो मान लो आपने एक विटनेस बुलाया, यू कॉल्ड अ विटनेस, अब वो डेलिबरेटली कह रहा है कि मैंने कुछ नहीं देखा. अब मान लो पहले उसने स्टेटमेंट दिया है कि मैंने ये सब देखा, सपोज ही वॉज एन आई विटनेस. पहले तो ये कहा था इसने कि मैंने देखा था, he made a statement to the police earlier, and now in the court he is saying that I have not seen anything. So that is where if the court finds that he is deliberately suppressing the facts and not revealing the facts, then he will be declared to be a hostile witness. Or suppose he starts naming some other person as accused. Now A is the accused today, and in the court he says that I saw B committing the crime and not A. So that is where again he becomes hostile. So the earlier statement he had made to the police, there he has declared that he had committed the crime. So there he is hostile. अब कई बार आपका witness, suppose your witness is illiterate, पढ़ा लिखा नहीं है, अब he goes to the court in examination in chief, he supports you. In examination in chief he supports you, but when he cross-examined, so his statements of cross-examinations are inconsistent. मतलब जो उसने एग्जामिनेशन इन चीफ में कहा था, जब उसका स्टेटमेंट क्रॉस एग्जामिनेशन में घबरा कर, बिकॉज ऑफ द प्रेशर ऑफ द अपोजिट लॉयर, ही स्टार्ट्स मेकिंग स्टेटमेंट्स विच आर नॉट वेरी कंसिस्टेंट इन देमसेल्व्स. अब पहले एग्जामिनेशन इन चीफ में उसने बोला था कि मैंने 50 मीटर के डिस्टेंस से क्राइम होते देखा है. अब क्रॉस एग्जामिनेशन जैसे उससे पूछा गया कि 50 मीटर क्या होता है, अब ही इज़ नॉट एबल टू से क्लियरली कि 50 मीटर कितना होगा, तो उसने वेरिंग डिस्टेंस बता दी कुछ अंदाज से. मान लो इस बिल्डिंग से अनदर बिल्डिंग तक 50 मीटर है. सो ही इज इनकंसिस्टेंट नाउ. अब merely because he does so, that does not render him hostile. अब a witness may make inconsistent statements in the court, merely because the witness not able to assert the fact that you have brought him for, that does not render him hostile unless you prove to the court that he has deliberately changed his statement. So mere minor inconsistencies in the statement will not declare a witness to be hostile. तो ये ध्यान रखिएगा, and that is a matter of practicality, and the court will examine the intent of the witness कि वो क्यों बना था witness. अब हम सेकंड पैराग्राफ की तरफ मूव कर रहे हैं. तो मान लो अब आप एक विटनेस को लेके गए. दिस इज अबाउट सेकंड पैराग्राफ. अब ही वॉज एन आई विटनेस. अब ही हैज स्टेटेड अर्लियर द एंटायर इंसिडेंट. He had seen the entire incident happening, and he had stated to the police the entire incident. And in fact, he was willing to recognize also. He is willing to recognize the accused also. अब TIP मान लो हुआ नहीं, TIP was not done, but he declared that if I see, then I will identify the accused. Now in the court, if he says, now he had seen the entire incident, so he speak the entire incident now also in the court, वैसा का वैसा जैसे पहले बताया था वैसा, लेकिन he refuses to identify the accused. So he says that no, I I am not able to remember because I have not seen the face of the accused. अब इसको बताओ हॉस्टाइल मानोगे कि नहीं मानोगे? Now you see this witness is not hostile in totality. Regarding the incident he is not hostile. घटना तो पूरा वही बता रहा है जो उसने देखा था, लेकिन आइडेंटिफिकेशन में he turned hostile. Earlier he has said that I had seen him and I can identify him if I see him again. Now he say that I do not see the face of the accused. So on the point of identification he had become hostile, but not in totality as such. So will you go for asking the questions of cross examination to such witness also? तो देखो क्या होता है, इसको समझना आप, दैट इज अ वेरी प्रैक्टिकल थिंग. मान लो आपके पास A, B, C 3 आई विटनेसेस हैं. देयर आर 3 आई विटनेसेस. अब तीनों ने पहले पूरी घटना बताई थी और तीनों ने कहा था कि मैं आइडेंटिफाई कर सकता हूँ बिकॉज आई हैव सीन द एक्यूज. अब कोर्ट में आकर ये गेव द एंटायर स्टेटमेंट एज इट इज. A give the entire statement as it is and plus A identified also. The B also made the entire statement plus he also identified. But C makes the entire statement but he refuses to identify. He says that I did not see the accused. Now this witness C has become hostile on the point of the identification of the accused. अब ये पूरा hostile नहीं हुआ है. He is not totally hostile. He has become hostile only to the point of identification. Normally, what the prosecution will do is they will not declare him the hostile witness. Why? Because आपके पास दो identification तो already हैं. Who has already identified the accused? अब C is the relevant in the sense, C के जो statement है that is the relevant in the sense that he has made the same statement as of A and B. He has made the same statement as A and B. And since he has made the same statement as A and B, so he is corroborating A and B at least regarding the incident. अब identification तो A and B ने कर ही दिया. Two people have identified. अब C का बयान is not totally against the prosecution. Not totally against the prosecution because he is supporting A and B regarding the happening of the incident. Only the identification is not done. So in such a case, the prosecution will not declare his witness as a hostile witness and will not go for 154. The reason being that this witness testimony at least can be used to corroborate the testimony of A and B. अब मान लो अगर C बिल्कुल ही पलट जाता और कहता कि मुझे I did not see anything and मुझे कुछ नहीं पता, then he will be hostile. क्योंकि चांसेस हैं कि कल को डिफेंस C को अपना विटनेस बना के खड़ा कर दे, तो उससे बेहतर होगा कि आप अभी उससे ऐसे सवाल पूछ लो ताकि उसकी क्रेडिबिलिटी को इम्पीच कर दो, ताकि कल को वो डिफेंस विटनेस बन के खड़ा ना हो. तो अगर C पूरी तरीके से हॉस्टाइल हो गया, he says that I did not see anything, then you will go for 154 and you will ask him questions to impeach his credit, etc., etc. So tomorrow if he wants to become a defense witness, then his credit is already impeached. But if otherwise he supported the prosecution to the material extent, excepting to the 1 or 2 point he's saying that I do not know. For example, identification he is refusing. So your witness is not totally turned hostile. So therefore you will not go against, you will not go for 154 against your accused, against your witness. You will not go for 154 against your witness. Is that fine? इसको भी लिख लीजिएगा आप. A witness may turn hostile only partly. A witness may turn hostile only partly, that is, he may not support the party on some point, though on the material points he supports the party. In such a case, normally the party who called him will not go for section 154, as on some material particulars he is supporting the party who called him. So is that fine? मतलब आप उस विटनेस को पूरी तरह से हॉस्टाइल तो नहीं मान रहे, क्योंकि वो कुछ पार्ट तो आपको सपोर्ट कर रहा है। अब उस केस में होगा क्या कि जो पार्ट आपके सपोर्ट में है वो पार्ट अगर फेवरेबल है उसको आप यूज़ करो अपने फेवर में। द कोर्ट विल यूज़ दैट in the favor of the prosecution, and the part which does not support, and if it is separable then that part can be removed. और अब हम यहाँ पे हमने आइडेंटिफिकेशन का एग्जाम्पल लिया है, बट देयर कैन बी एनी अदर काइंड ऑफ विटनेसेस in which evidences in which he supports the material particulars of the case, the prosecution witness, but on one or two points he did not support. Rather, he made one or two statements which may have gone in the favor of the defense or opposite party. And if the court is sure that the witness has turned hostile, then court will break the statement in two parts: the one who supports the prosecution or the party who called him, and the one who does not. The court will break it into two parts: the one who supports the party and one who does not. And the court will use the supporting wala part in favor of the prosecution, or the party who called him. अब इसमें आप सेकंड वाला पार्ट पढ़िए. Nothing in this section shall disentitle the person so permitted under subsection 1 to reply on any part of the evidence of such witness. The same thing I told you right now. Nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such witness. Nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such witnesses. Of that part of the evidence which support that part of the evidence which supported that party, if it is severable, you can always use it in your favor, and the other part which does not support you, that can be rejected. So that is what they are saying. अब एक मैक्सिम बताया था मैंने आपको पहले भी, falsus in uno, falsus in omnibus. So write down the meaning. If a witness makes a statement which is partly correct and partly wrong, then the entire statement of the witness will be considered to be false. मतलब विटनेस ने कुछ पार्ट झूठ बोला और मतलब कुछ पार्ट में आपको सपोर्ट नहीं किया और कुछ पार्ट उसने सच बोला, मतलब आपको सपोर्ट किया कुछ पार्ट में, तो पूरा स्टेटमेंट फॉल्स माना जाएगा. द एंटायर स्टेटमेंट विल बी डिस्कार्डेड. अब इज इट नॉट अगेंस्ट द स्पिरिट ऑफ द क्लास 2 हियर? Class 2 says that you can break it and partly support, that you can use. So this is the maximum applicable in England and not in India. So एक सेंटेंस और लिख लो, this maximum applies only in England and not in India, and therefore इस मैक्सिम से इंडिया में इस मैक्सिम का कोई रोल नहीं है, because section 154 clearly says that you can separate the part, and the part which supports you can use in your favor. अब suppose a witness partly supported you and partly becomes hostile, तो जिस पार्ट में वो हॉस्टाइल हुआ है उस पार्ट के लिए आप 154 क्लॉज 1 यूज कर सकते हो. लेकिन एक बात याद रखना कि अगर आपने विटनेस का क्रेडिबिलिटी ब्रीच कर दिया तो जो पार्ट सपोर्ट कर रहा है वो भी चला जाएगा, तो आप कितना उसको क्रॉस एग्जामिनेशन वाले सवाल पूछोगे वो देखना पड़ेगा. तो जिस पार्ट में आपका विटनेस हॉस्टाइल हुआ है उस पार्ट पर आप क्रॉस एग्जामिनेशन वगैरह का सवाल पूछ लो, लेकिन जिस पार्ट में वो आपको सपोर्ट कर रहा है वो पार्ट आप फिर भी यूज़ कर लोगे, उसको आप फिर भी यूज़ कर सकते हो. तो ये भी लिख लीजिए आप, राइट डाउन. राइट, इफ़ द विटनेस टर्न्स हॉस्टाइल If the witness turns hostile partly only, then the party calling a witness may use section 154 clause 1 against that witness, but he may still rely upon that part in which the witness supports. But he may still rely upon that part in which the witness supports him. तो यहाँ पे क्वेश्चन सिर्फ इतना रहेगा कि जो उसका हॉस्टाइल वाला पार्ट है उसमें कोर्ट से परमिशन लेकर आप अगर क्वेश्चन पूछते हो, उस पर आप क्रॉस एग्जामिनेशन वाले सवाल पूछते हो और आपने डायरेक्ट अपने विटनेस का क्रेडिट इम्पीच कर दिया, इफ यू इम्पीच हिज क्रेडिट बाय इंजरिंग हिज कैरेक्टर, देन this is for the entire statement, and therefore if you are using 154 clause 1 and if it is for some part of the statement, then you have to be very cautious upon asking questions. आप उसके veracity regarding that part पर क्वेश्चन आस्क कर लो, लेकिन आप अगर जनरली उसकी क्रेडिट इम्पीच करोगे फिर तो सारा स्टेटमेंट चला जाएगा. So is it clear to you? So that is what about this topic. All the dimension I have told you. अब कोर्ट में जाओगे प्रैक्टिकलिटी में तो इस पे हॉस्टाइल विटनेस पे आपको मोटी मोटी किताब मिल जाएंगी, लेकिन सबकी समरी यही है व्हाट आई हैव स्टेटेड. सबका सम्मेशन यही होगा जो हमने डिस्कस किया. नाउ नेक्स्ट आफ्टर दिस सेक्शन 155. सेक्शन 155 प्लीज. द क्रेडिट ऑफ अ विटनेस मे बी इम्पीच्ड इन द फॉलोइंग वेज बाय द एडवर्स पार्टी. अब इसमें ज़्यादा कुछ है नहीं, जस्ट अ रीडिंग इज रिक्वायर्ड. The credit of a witness may be impeached in the following ways by the adverse party or with the consent of the court by the party who calls him. Why should the party who calls him impeach the credit? Obviously, when the witness become hostile. So मैं अपने witness का भी credit impeach कर सकता हूँ with the permission of the court, और opposite party के witness का भी credit impeach कर सकता हूँ. अपोजिट पार्टी के विटनेस का क्रेडिट भी इम्पीच कर सकता हूँ बाय दीज मेथड्स. पहला, बाय द एविडेंस ऑफ पर्सन्स हु टेस्टिफाई दैट दे फ्रॉम देयर नॉलेज ऑफ द विटनेस बिलीव हिम टू बी अनवर्दी ऑफ क्रेडिट. सो द पीपल मे कम एंड दे गिव द एविडेंस दैट नो दिस मैन इज नॉट ट्रस्टवर्दी. तो उसका कैरेक्टर आप इम्पीच कर रहे हो बेसिकली, या फिर आप लोगों को बुलाकर उसका रेपुटेशन या डिस्पोजिशन का एविडेंस आप करवा दो कि दिस मैन इज नॉट ट्रस्टवर्दी ऑफ क्रेडिट. देन सेकंड, बाय प्रूफ दैट द विटनेस हैज बीन ब्राइब्ड और हैज एक्सेप्टेड द ऑफर ऑफ ए ब्राइब और हैज रिसीव्ड एनी अदर करप्ट इंड्यूसमेंट टू गिव हिज एविडेंस. मतलब विटनेस ने अगर ब्राइब लिया है या ब्राइब के लिए एग्री कर गया है या एनी सच मेथड, और उसके बाद वो एविडेंस देगा, तो आप अगर ये प्रूव कर दो, देन ऑल्सो हिज क्रेडिट इज इम्पीच्ड. तो या तो यू गो टू द कोर्ट, विटनेसेस गो टू द कोर्ट एंड गिव द एविडेंस that this particular witness is unworthy of the credit in their opinion, or you prove directly that he has taken bribe. Or number 3, by proof of former statements inconsistent with any part of his evidence which is liable to be contradicted. By proof of former statements inconsistent with any part of his evidence which is liable to be contradicted. Now here you see, do you find some kind of similar thing here and 145? 145 में भी तो आप contradict करते हो witness को on the basis of the former statement, and here you impeaches his credit on the basis of the former statement. पहले उसने किसी को कुछ कहा था क्या या फिर लिखा था, and today he is saying something else. So on the basis of that former statement also you can impeach his credit. बस difference ये है that 145 is only related to written documents, and this here it can be oral or written both. ये मेन पॉइंट है। 155 क्लॉज 3 में स्टेट जो हम प्रीवियस स्टेटमेंट की बात कर रहे हैं, 155 क्लॉज 3 में प्रीवियस स्टेटमेंट कैन बी ओरल और रिटन स्टेटमेंट, इट कैन बी ओरल और रिटन, जबकि 145 में इट हैज टू बी अ रिटन डॉक्यूमेंट। अब ये पार्टी का चॉइस है, पार्टी में कॉन्ट्राडिक्ट द विटनेस ऑन द बेसिस ऑफ, a party may contradict the witness on the basis of the previous statement, or under this section he may go for impeach his credit। लेकिन अगर ओरल है, स्टेटमेंट अगर ओरल है, तो फिर कॉन्ट्राडिक्शन नहीं हो सकता, कॉन्ट्राडिक्शन नहीं हो सकता। he can only impeach the credit of the witness by proof of former statements inconsistent with any part of his evidence which is liable to be contradicted। Now see the explanation। A witness declaring another witness to be unworthy of credit। अब ये किस क्लाउज से रिलेटेड है? क्लाउज 1। क्लाउज 1, a witness declaring another witness to be unworthy of credit may not, upon his examination in chief, give reasons for his belief, but he may be asked his reasons in cross examination, and the answers which he gives cannot be contradicted, though if they are false he may afterwards be charged with giving false evidence। He may be afterward be charged with giving false evidence। Now what happens is, suppose you are a witness brought by a party, by the prosecution suppose. So you are a witness brought by the prosecution, suppose prosecution witness, and defense is having another witness, that is defense witness। Now this witness, prosecution witness, stands into the court। अब suppose I am the defense witness, अब I stand into the court and say that this witness, prosecution witness, is untrustworthy। तो मैं भी एक witness हूँ जो दूसरे witness के लिए कह रहा है that this witness is untrustworthy। अब मेरे examination in chief में जब मैं ये कहूँगा this witness is untrustworthy, तो फिर मुझे उसके कारण नहीं बताने। But when your party cross examines me and they ask me that on what basis you suggest that he is untrustworthy, then I will give reasons why I am saying that he is untrustworthy or unworthy of credit। But when I give the reason that he is not worthy of credit, now the opposite party, your party, he cannot contradict me। तो 153 में भी तो यही पढ़ा था आपने। तो वो एविडेंस देकर मेरे स्टेटमेंट को कॉन्ट्राडिक्ट नहीं कर सकता। लेकिन अगर मैंने कोर्ट में झूठा बयान दिया है, then he can always prosecute me for false evidence। ओके, सपोज ये प्रोसिक्यूशन है, फिर से देखते हैं कंफ्यूजन दूर करने के लिए। ये प्रोसिक्यूशन है, प्रोसिक्यूशन ने एक विटनेस को बुलाया, प्रोसिक्यूशन जिस विटनेस को बुलाया वो पीडब्ल्यू है, डिफेंस ने एक विटनेस को बुलाया डीडब्ल्यू को। अब डीडब्ल्यू का एग्जामिनेशन इन चीफ में बयान है दैट पीडब्ल्यू इज अनवर्दी ऑफ क्रेडिट। डीडब्ल्यू का एग्जामिनेशन इन चीफ में बयान है कि पीडब्ल्यू इज अनवर्दी ऑफ क्रेडिट। अब एग्जामिनेशन इन चीफ पे ही विल नॉट गिव द रीजंस फॉर दैट, he will not give reasons for that, he may not give reasons for that। now here the prosecution will cross examine DW। अब DW का जब cross examination होगा, then DW will be asked that on what basis you are saying that he is unworthy of credit। so the DW will now give the reasons, DW will now tell the basis। अब when DW tells the basis, reasons, when DW gives the basis of that DW is unworthy of credit, then can the prosecution give evidence to contradict this fact? Can the prosecution give the evidence to contradict the truthfulness of the fact which DW has stated? Answer is no. No. But yes, if DW has given false evidence, then on that basis, the DW can prosecute it for false evidence. But that in a different trial. Okay. अब लेकिन मान लो प्रोसिक्यूशन विटनेस आया और डिफेंस ने उसकी क्रेडिट को इम्पीच करने के लिए डीडब्ल्यू को बुलाया और डीडब्ल्यू ने अपने एग्जामिनेशन इन चीफ में कहा कि दैट आई बिलीव दैट ही इज अनवर्दी ऑफ क्रेडिट। अब डीडब्ल्यू भी एक विटनेस है, उसका भी क्रॉस एग्जामिनेशन होगा। तो पीडब्ल्यू ने पूछा कि आप किस बेसिस पे कह रहे हो कि ही इज अनवर्दी ऑफ क्रेडिट। तो डीडब्ल्यू ने कहा कि पहले भी ये झूठा बयान देने के लिए 2-3 बार पनिश हो चुका है, पहले भी ये झूठा बयान देने के लिए पनिश हो चुका है, या फिर पहले भी ये चोरी वगैरह करता रहा है। तो ये आपने अपना बेसिस बताया, ऑन दैट बेसिस आई बिलीव दैट ही इज अनवर्दी ऑफ क्रेडिट। अब कैन द प्रोसिक्यूशन नाउ गो ऑन टू प्रूव दैट द प्रोसिक्यूशन विटनेस नेवर हैव बीन कन्विक्टेड फॉर थेफ्ट और गिविंग फॉल्स एविडेंस एक्सेट्रा? आंसर इज नो। बट इफ दिस DW has given false evidence, जो उसने कहा है वो झूठ है, तो later on he can always be prosecuted for false evidence. So read it once again. A witness declaring another witness to be unworthy of credit may not, upon his examination in chief, give reasons for his belief, but he may be asked his reasons in cross-examination, and the answers which he gives cannot be contradicted, though if they are false. Though if they are false, he may be afterward be charged with giving false evidence. ठीक, तो झूठा बयान देने के लिए आप उसको चार्ज करके पनिश कर सकते हो। अब इलस्ट्रेशंस देखिए आप। A sues B for the price of goods sold and delivered to B. A ने कुछ गुड्स बेचे थे B को, B ने प्राइस नहीं दिया है। A sues B for the price of goods sold and delivered to B. C says that he delivered the goods to B. C says that he delivered the goods to B. मतलब C ने बयान दिया विटनेस बनकर कि मैंने गुड्स B को दे दिए थे। अब the evidence is offered to show that on a previous occasion he said that he had not delivered goods to B. The evidence is admissible. Under which clause? Third clause, clause C, clause 3. क्योंकि अभी B ने क्या कहा है कि I have delivered the goods to B, और पहले उसने किसी को कहा था कि मैंने तो गुड्स दिए ही नहीं उसको। अब जो पहले उसने स्टेटमेंट किया था, मान लो इट वाज एन ओरल स्टेटमेंट, तो उसके बेसिस पर आपका क्रेडिट इम्पीच हो सकता है क्लॉज 3 में, 155 क्लॉज 3 में उसके बेसिस पर आपका क्रेडिट इम्पीच हो सकता है। सो इज दैट फाइन? नाउ सी इलस्ट्रेशन बी। इज इंडिक्टेड फॉर द मर्डर ऑफ बी। is indicted for the murder of B. C says the B when dying declared that A had given B the wound of which he died. C कह रहा है B ने मुझे मरने के पहले बताया था कि A ने उसको इंजरी किया है जिसकी वजह से वो मर रहा है। Means C says that he make the dying declaration to me. Now evidence is offered to show that on a previous occasion C said that the wound was not given by A or in his presence. The evidence is admissible. In which clause? That is in clause 3. तो ये दोनों illustration clause 3 के ही हैं। Now after that 156 आप पढ़ लीजिएगा, 157 we have done. Now 158 onwards we have to look, 158, 159 etc. Section 158. Whenever any statement relevant under section 32 or 33. अब याद करो सेक्शन 32 डाइंग डिक्लेरेशन वगैरह, एंड 33 इज अगर कोर्ट में बयान दिया है तो whenever any statement relevant under section 32 or 33 is proved, all matters may be proved either in order to contradict or to corroborate it, or in order to impeach or confirm the credit of the person by whom it was made, which might have been proved if that person had been called as a witness and had denied upon cross-examination of the truth the matter suggested. अब आप याद करो 32, 33 में there is a person who died or absconding. He had made a statement. In 32 he has made a statement and in 33 he has given the evidence. So for now think only about 32. 33 साथ साथ समझ में आ जाएगा, तो अभी खाली 32 का एग्जाम्पल लेके चलते हैं इस सेक्शन में। अब कोई व्यक्ति है, वो मर चुका, ही इज डेड, he cannot be brought into the court, or maybe he is absconding, etc. अब you are proving his statement in the court today, you cannot bring him in the court. So the person to whom he has made the statement, that person comes to the court to prove that he had said so earlier, and he had said so before the controversy had arisen. If you remember all that. Whenever any statement relevant under section 32 or 33 is proved, all matters may be proved either in order to contradict or to corroborate it. तो मान लो अगर उस व्यक्ति ने कुछ कहा था पहले, और आज आप उसका बयान, उसका स्टेटमेंट कोर्ट में प्रूव कर दो। अब अगर अपोजिट पार्टी किसी और को बुला ले और वो ये प्रूव कर दे कि उसने मुझे कुछ और कहा था। अब सपोज देयर इज वन ए हु सेड दैट एक्स इज द सन ऑफ वाई, so that he said to Z. अब Z comes to the court and gave the testimony that A had said this to me. Now the opposite party brings some P. Now the P says that A had told me that X is not the son of Y. So can you, by his previous statement, contradict him or impeach his credit? किसका क्रेडिट? किसका क्रेडिट? उस व्यक्ति का जो मर गया है, उसका बयान। उसने कहा था एक्स इज द सन ऑफ वाई, जिसको कहा था वो कोर्ट में आके बयान दे रहा है। अपोजिट पार्टी ने किसी और को बुला लिया, उसने कहा कि उसने मुझे कहा था एक्स इज नॉट द सन ऑफ वाई। अब इज इट नॉट दैट द क्रेडिट सेड इम्पीच्ड? नाउ ही इज नॉट द विटनेस हियर, दैट पर्सन इज डेड। फिर भी आप उसके स्टेटमेंट के ट्रुथफुलनेस को इम्पीच कर सकते हो। इफ यू रीड इट केयरफुली, whenever any statement relevant under section 32 or 33 is proved, all matters may be proved either in order to contradict or to corroborate it. It मतलब that statement. It means that statement that he has made earlier, or in order to impeach or confirm the credit of the person by whom it was made. Now they are not talking about the impeaching the credit of the witness. They are talking about the credit of the person by whom that statement was made. Or in order to impeach or confirm the credit of the person, or in order to impeach or confirm the credit of the person by whom it was made, which might have been proved if that person had been called as a witness. मतलब अगर वो व्यक्ति विटनेस बनकर आता, तो जिस तरीके से आप उसके स्टेटमेंट को कॉन्ट्राडिक्ट कर सकते थे, उसकी क्रेडिट को इम्पीच कर सकते थे। अब तो वो विटनेस बनकर नहीं आया, बेचारा मर गया, तो फिर भी आप वो सारे एविडेंसेस दे सकते हो जिससे उसका क्रेडिट इम्पीच हो जाए या उसका स्टेटमेंट कॉन्ट्राडिक्ट हो जाए, एक्सेट्रा। ठीक? दे आर नॉट टॉकिंग अबाउट द इम्पीचिंग द क्रेडिट ऑफ द विटनेस हु हैज कम। उसको तो आप कर ही सकते हो अलग से, उस पर तो देयर इज नो डाउट, बट द पर्सन हुज स्टेटमेंट इट वाज, उसकी क्रेडिबिलिटी को, हैड ही appear as a witness, the person who made the statement, the A in my example, had he himself appear as a witness. So whatever you could have done to him, impeaching related etc. Now even if he is not a witness now, even if he is dead etc., even though all those proceedings taken in order to disprove his statement. अब मान लो एक डाइंग डिक्लेरेशन वाला व्यक्ति मर गया है। अब अगर वो खुद आता कोर्ट में और बयान देता, अगर वो नहीं मरा होता और खुद आकर कोर्ट में बयान देता, तो उस व्यक्ति के खिलाफ, व्यक्ति मतलब विक्टिम, सॉरी विटनेस, व्यक्ति मतलब विटनेस, तो उस व्यक्ति के खिलाफ आप जो जो कर सकते थे अंडर 155 और एनी अदर प्रोविजन। अब इस डाइंग डिक्लेरेशन वाले एग्जाम्पल में तो जो विटनेस होता, वो अगर जिंदा होता तो वो खुद ही विटनेस होता, तो विक्टिम, so is victim itself. So it is little bit confusing for you. I am repeating this example again. मान लो एक डाइंग डिक्लेरेशन वाला व्यक्ति मर गया है, वो अगर वो खुद आता कोर्ट में और बयान देता, और अगर वो नहीं मरा होता, खुद कोर्ट में बयान ना कर देता, तो उस व्यक्ति के खिलाफ, व्यक्ति मतलब विक्टिम, अब जो मर गया विक्टिम एज विटनेस आता, तो उस व्यक्ति के खिलाफ आप जो जो कर सकते थे अंडर 155 और एनी ऑफ अंडर एनी ऑफ अदर प्रोविजन, all that can be done here regarding the dying declaration. Now suppose A has sought upon B. अब B has died. अब B makes a statement to C that A sought, and B makes a statement to D that X sought. अब दो डाइंग डिक्लेरेशन किया उसने, एक में कह रहा है कि A ने गोली मारी और दूसरे में कह रहा है X ने गोली मारी। अब B is dead, तो एक से कह रहा है A ने गोली मारी, एक से कह रहा है X ने गोली मारी। अब B is dead. Now C comes to court as a witness that B had made a dying declaration to me. Now suppose B himself would have alive and B himself have come to court saying that A has sought upon me. Then can the opposite party brought D and prove D? D will come into the court and say that D will come to the court and say, but to me he has said that X has sought him. Will not the credit of B was impeached by that? 155 clause 3. अब देखो, दोबारा देखते हैं इसको। A shot upon B and B died. अब देखो, पहले पढ़ते हैं इसको। Whenever any statement relevant under section 32 और 33 is proved. देखो, किसी भी सेक्शन को पढ़ने के लिए, समझने के लिए क्या जरूरी है कि एक बार पूरा सेक्शन पढ़ लिया, ठीक है, फिर दोबारा आए, फिर दोबारा सेक्शन का शुरू का पार्ट पढ़ा, फिर उसको अनफोल्ड किया, फिर उसको समझा, फिर दोबारा पढ़ा सेक्शन, फिर उसका बाकी का पार्ट, दूसरा पार्ट अनफोल्ड किया, फिर ऐसे ही धीरे धीरे करके सारे पार्ट्स अनफोल्ड करते चलेंगे, बार बार पढ़ गए। तो एक ही बार में अगर पूरा सेक्शन पढ़ गए आप समझना चाहोगे तो इस तरीके से आप नहीं समझ पाओगे और ना आपको क्लियर होगा। तो पहले एक बार सेक्शन को पूरा पढ़ लो, ब्रॉड स्प्रेड पकड़ लो, उसके बाद उसके पार्ट्स को समझो, एंड देन यू लुक एट टू द होल सेक्शन, तब समझ में आएगा आपको। ये तो बहुत सिंपल सेक्शन है, बट अदरवाइज फॉर ऑल सेक्शन अदर सेक्शंस आई एम सेइंग दैट। अब जैसे यहाँ पर पढ़ा आपने, वेन एवर एनी स्टेटमेंट रेलिवेंट अंडर सेक्शन 32 और 33 इज प्रूव्ड, तो अब आप यहीं पर रुक जाओ। अब विजुलाइज करो आप व्हाट इज दिस सेक्शन 32 और 33। अगर याद ना आए तो उस पर 32 और 33 को एक बार दोबारा पढ़ कर आओ, और ये भी देख लो कि 32 और 33 दोनों है, तो अगर मैं एक को भी लेकर समझ गया तो फिर 33 दूसरा वाला अपने आप समझ में आ जाएगा। एक का एग्जाम्पल समझ गया तो दूसरे का एग्जाम्पल अपने आप समझ में आ जाएगा। अब 32 में आप कोई एग्जाम्पल उठा लो, 32 क्लास 3 का, 5 का, या डाइंग डिक्लेरेशन का उठा लो, और रिकॉल करो दैट द स्टेटमेंट मेड बाय अ पर्सन हु वाज डेड, हु इज प्रेजेंटली डेड और एब्सकॉन्डिंग, एंड ही हैज मेड द स्टेटमेंट इन द ऑर्डिनरी कोर्स ऑफ ट्रांजैक्शन before the controversy had arisen. I am not talking about the dying declaration, I am talking about the rest of the section. Dying declaration में तो इंजरी हो चुकी already. So before the controversy had arisen, some witness to whom he had made the statement or document in which he had made the statement will be proved today in the court. तो जब तक ये विजुलाइज नहीं करोगे तब तक आगे का समझ में नहीं आएगा। तो आप अपने दिमाग में बना लो that there was one B who made the statement. He made the statement to some D. B is dead today, and D comes to the court to give evidence. So today D is giving the evidence. Now are they talking about the impeaching the credit of B, or are they talking about the impeaching the credit of D? तो जैसे ही इस तरीके से सवाल आप दिमाग में बनाओगे वैसे ही आपको ये आंसर समझ में आ जाएगा। So B is the person who made the statement और D is the person, ये स्टेटमेंट किसको दिया था इसने यहाँ पर, सी और डी को दिया था। अब सी को मान लेते हैं सी इज द पर्सन हु गिव द टेस्टिमनी इनटू द कोर्ट, बी वाज द पर्सन हु डाइड, बी वाज द पर्सन हु डाइड हु मेड द स्टेटमेंट, एंड सी इज द पर्सन हु मेड द टेस्टिमनी इनटू द कोर्ट टुडे। फिर से पढ़िए इसको। whenever any statement relevant under section 32 or 33 is proved, all matters may be proved either in order to contradict or to corroborate it. Now, what do you mean by all matters may be proved either in order to contradict or to corroborate it? Some previous statement, some previous statement. The party who has got some C as a witness, so he makes some previous statement to B by which he can corroborate it, or the opposite party may with some previous statement by which he can contradict him. तो मतलब ये 157 145 की बात कर रहे हैं, लेकिन कॉन्ट्राडिक्ट किसको? अगर सी को कॉन्ट्राडिक्ट करना होता तो फिर वो अलग से लिखने की जरूरत ही नहीं, वो तो हम ऑलरेडी समझ चुके हैं कि किसी विटनेस को हम 145 में कॉन्ट्राडिक्ट कर सकते हैं। तो ये किसके कॉन्ट्राडिक्शन की बात कर रहे हैं, तो वो अब आपको सोचना होगा आगे पढ़कर। बेसिकली मैं आपको ये बताने की कोशिश कर रहा हूँ कि सेक्शन को कैसे ब्रेक कर करके पढ़ते हैं जिससे सेक्शन आपको पूरा समझ में आ जाए, क्योंकि बहुत सारे सेक्शन तो आपको जो हमने कवर नहीं किए वो आपको खुद पढ़ने अदर सब्जेक्ट्स में। तो आगे देखो, ऑल मैटर्स में बी प्रूव्ड एदर इन ऑर्डर टू कॉन्ट्राडिक्ट और टू corroborate it or in order to impeach or confirm the credit of the person by whom it was made, or confirm the credit of the person by whom it was made, in order to impeach or confirm the credit of the person by whom it was made। अब जैसे ही आपने पढ़ा by whom it was made, अब that by whom is whom, अब आपके दिमाग में आएगा is that B और C। अब अगर C का क्रेडिट इम्पीच करना होता तो वो ऑलरेडी हम 155 में कर ही रहे हैं। व्हाट इज स्पेशल अबाउट दिस सेक्शन? So obviously they are talking about the original person who had made the statement. अब impeaching the credit of the person is 155, 155 यूज कर लो, 146 यूज कर लो। 146 तो मान लो आप सवाल पूछोगे तो वो तो मर गया, उससे क्या सवाल पूछोगे, लेकिन 145 में कॉन्ट्राडिक्ट तो कर सकते हो, क्योंकि 146 में तो यू आस्क क्वेश्चंस। अब क्वेश्चन कैसे पूछोगे क्योंकि वो मर चुका है। Therefore here what will apply? 145, 157 or 155, because 146, 140 etc., 48 etc., they will not apply because there you ask questions, and how can you ask the questions to the person who is already dead? समझ आया? फिर आगे, of the person by whom it was made, they are saying which might have been proved, which might have been proved means the matter 155, 145 etc., which might have been proved if that person B had been called as a witness and had denied upon cross examination of the truth the matter suggested। तो मतलब जिस तरीके से आप ओरिजिनल पार्टी को बुलाकर क्रॉस एग्जामिनेशन वगैरह जो भी कर सकते थे, वैसे ही आप अभी भी कर सकते हो। अब वो तो है नहीं, तो क्रॉस एग्जामिनेशन वाले सवाल तो आप पूछोगे नहीं, लेकिन यस यू कैन ऑलवेज कॉन्ट्राडिक्ट हिम और impeach his credit etc. So is that fine? That is how you have to read the section, क्योंकि ultimately entire game is about sections, सारा खेल sections का ही है। If you know the sections you know the law। अब इस एग्जाम्पल में what I have said was, what I had said in this example, that A sought upon B, sought upon या stabbed, तो suppose A sought upon B and in one statement he made two statements. B made two statements. In one statement he made to C, he said that A sought upon me. B said to C that A sought upon me. And another statement, B said to D that X has sought upon me. X has sought upon me. Ab, in the trial, C goes to the court to give the testimony that B has deposed me, that A has stabbed me. That B has deposed to me that A has stabbed him. C is a prosecution witness. Now defense gets the D as a witness. Defense gets the D as a witness for what? For impeaching the credit under 155 clause 3, because स्टेटमेंट ओरल है तो कॉन्ट्राडिक्ट भी नहीं कर सकते, तो ओरल स्टेटमेंट में तो कॉन्ट्राडिक्शन भी नहीं कर पाओगे, रिटन होता तो कॉन्ट्राडिक्ट करते, ओरल है इसलिए 155 क्लास 3 की बात कर रहा हूँ। अब डी को डिफेंस ने प्रोड्यूस किया और डी कोर्ट में खड़े होकर बयान देता है कि मुझे तो बी ने कहा था कि एक्स ने मारा है उसे। अब अगर मान लो सी की जगह बी खुद कहता कोर्ट में कि मुझे ए ने मारा है, और अब डी खड़े होकर कहता उसको कोर्ट में एज अपोजिट साइड का विटनेस कि मुझे तो इसने कहा था कि इसको एक्स ने मारा है, तो बताइए क्या बी का क्रेडिट इम्पीच होता डी के इस बयान से? If B himself stand into the court and said into the court that I have sought by A, and defense produces D to prove a previous statement of B, oral statement, that B had earlier told to D that X has sought upon him. Now, is it not the something which is going to impeach the credit of B under section 155 clause 3? Yes. तो अगर B के लिए D would have impeached his credit, तो D can be brought to the court to prove that the statement made by B was not correct. अब देखो B तो मर चुका है वैसे, लेकिन जिस विटनेस से आप B का क्रेडिट इम्पीच कर सकते थे, B मर गया है, फिर भी आप उस विटनेस को लाकर उसका बयान करवा सकते हो। ओके, सेक्शन 159 now. That is the last topic for examination. Refreshing of memory. You see what happened is, suppose there is a witness and he had made a statement earlier which is in a recorded form. Earlier he has made a statement which is in a recorded form. Then this witness appears into the court and he is examined in chief, and after that he has been cross-examined. Now in the cross-examination certain questions are asked to him and he is not able to recall. कुछ डिटेल्ड क्वेश्चन पूछे गए उससे, but he was not able to recall the entire incident. So there what will happen is, he will be allowed by the court to look at the previous document, जो भी उसने पहले लिखा था. अब suppose today, for example, today I saw an incident happening. And about that incident, I went home and I wrote it on a document, maybe a diary or something. I wrote it. Now in the court, maybe after 1 year or 2 years, when the trial starts, I appear in the court and I gave evidence. Now in examination in chief, तो चलो questions are asked, I answered because I was aware of the things to that extent, so I was able to make the reply. If the opposite party starts cross-examining me and he starts asking me further details, maybe after 1 or 2 years I have forgotten the entire details. Maybe superficial things are remembered, so to that extent in examination in chief. But in cross-examination, when the further details are asked to me, I am not able to recall the entire details. So there the refreshing of memory come into frame, and under section 159 I will be allowed to look at the page of my diary. Then I will see the page of my diary and I will read the entire thing. सुनिएगा बड़े ध्यान से इसको. I will read the entire thing and then the page will be taken back from to me. ऐसा नहीं है कि मैं देख देख कर जवाब दूंगा. And it will be allowed to recall my memory or refresh my memory by reading that page. Once I have read it, the page is removed and now again the cross-examination is done. After taking the page, and now since I have recalled, then I may be able to answer questions, reply to the questions. So that is what is called refreshing of memory. अब इसी में एक चीज़ और होता है कि मान लो मुझे उस कागज़ को पढ़ने के बाद मुझे लगता है कि मैं मेमोरी रिकॉल नहीं कर पा रहा हूँ, मुझे कुछ याद नहीं आ पा रहा है, सुपरफिशियल चीज़ें याद हैं लेकिन पूरा डिटेल्स याद नहीं आ पा रहा, तो वैसे केस में पढ़ने के बाद भी आई एम नॉट एबल टू रिप्लाई दैट क्वेश्चन. सो व्हाट कैन बी डन इज, in that case, I will give the testimony to the court that, look, I am not able to recall everything, but this document I had written immediately after when my memory is fresh, and I recall this much at least, that whatever written in this document was correctly written. अब अगर ये सिचुएशन होगा तो then that matter will fall under which section 160. तो अगर मैं रिकॉल करके खुद जवाब देता हूँ तो देन सेक्शन 159, लेकिन रिकॉल करने के बाद भी जवाब नहीं दे पा रहा, लेकिन ये एविडेंस दे रहा हूँ कि जो इसमें लिखा है that was correctly recorded, I remember that it was correctly recorded at that time. तो उस केस में I can give the testimony regarding the document successfulness. अब मेरा oral evidence तो नहीं हो पाएगा because I am not recall everything, but yes, the document will be admissible and I will testify that the document is correctly written. That is 160. Now you read the section 159. A witness may, while under examination. While under examination means what? The process of examination is going on. पहले से नहीं, examination चल रहा है. Refresh his memory by referring to any writing made by himself. A witness may, while under examination, refresh his memory by referring to any writing made by himself. ठीक, writing made by himself earlier. Writing made by himself at the time of the transaction concerning which he is questioned, or so soon afterwards that the court considers it likely that the transaction was at the time fresh in his memory. मतलब विटनेस आज कोर्ट में बयान दे रहा है, he is not able to recall everything, he may refresh his memory on the basis of the document which he had written earlier at the time when the transaction took place, or so soon after that the court believes that at that time, मान लो आज घटना हुई है उसके 5 दिन के अंदर 10 दिन के अंदर, the court believes that the memory may have been fresh at that time. Then in that case the document will be allowed to him to refresh his memory. Then the witness may also refer to any such writing. अब पहले वाले में तो था जो डॉक्यूमेंट उसने खुद लिखा वो, अब सेकंड पैराग्राफ में कह रहे हैं the witness may also refer to any such writing made by any other person and read by the witness within the time aforesaid, if when he read it he knew it to be correct. अब मान लो हम दो दोस्त हैं, we are two people, we saw a murder happening, I went home, you also went home, maybe today itself or within a reasonable time. You wrote on a piece of paper, or you wrote a letter to me, you wrote everything, every incident of that crime, you wrote entire thing, that how horrified it was, friend, I am still haunted by the memory of that incident. You delivered that letter to me, like how brutally the person killed, etc., etc. You written everything. Then I read the letter, then I remember that it was correctly written. Every fact was correctly written. अब आफ्टरवर्ड्स कल को कोर्ट में मैं विटनेस बन के आया मानो, तो या तो मैंने खुद अगर कुछ लिख रखा था तो उसको लेकर मैं मेमोरी रेफ्रेश कर लूँगा, और या फिर और जो लेटर आपने लिखा था that letter can also used by me to refresh my memory. That letter can also used by me to refresh my memory. Now that letter was not written by me, that was written by some third person. But when I read it earlier, then I remembered that whatever written in it, that was correct. It is correctly written. तो या तो मेरा खुद का लिखा गया डॉक्यूमेंट या फिर किसी थर्ड पर्सन का लिखा गया डॉक्यूमेंट जिसके बारे में आपको उस समय विश्वास था जब आपने पढ़ा था उसको, जो लिखा है वो सच लिखा है. So you can recall your memory on the basis of either of these two documents, written by you or written by third person, but read by earlier that you believe that the document was correctly written. अब next पैरा देखो. Whenever a witness may refresh his memory by reference to any document, he may, with the permission of the court, refer to a copy of such document. तो आप ओरिजिनल से भी रिफ्रेश कर सकते हो या फिर कोर्ट की परमिशन एक्सेट्रा लेकर या फिर कोर्ट की परमिशन लेकर उसकी जेरॉक्स कॉपी एक्सेट्रा से भी आप मेमोरी रिफ्रेश कर सकते हो। यू कैन रिफ्रेश योर मेमोरी ऑन द बेसिस ऑफ ओरिजिनल और विद द परमिशन ऑफ द कोर्ट, द जेरॉक्स कॉपी एक्सेट्रा ऑफ दैट। और यहाँ पर सेक्शन 65 का कोई रोल नहीं है, बिकॉज इस डॉक्यूमेंट में वी आर नॉट प्रोड्यूसिंग एविडेंस, यू आर सिंपली रिफ्रेशिंग योर मेमोरी, देयरफॉर 65 प्रूव करने की जरूरत नहीं है। सिंपली यू कैन सीक परमिशन फ्रॉम द कोर्ट that can I refresh my memory on the basis of the Xerox copy. Whenever a witness may refresh his memory by reference to any document, he may, with the permission of the court, refer to a copy of such document, provided the court be satisfied that there is a sufficient reason for the non-production of the original. So I told you 65 प्रूव करने की जरूरत नहीं पड़ेगी। सर्कमस्टेंस तो 65 जैसे ही होंगे, लेकिन फिर भी द कोर्ट हैज़ द डिस्क्रिशन टू अलाउ, क्योंकि तुम कॉपी से क्यों रिफ्रेश करना चाहते हो, कॉपी से क्यों रिफ्रेश करना चाहते हो, तो यू कैन ऑलवेज से दैट द ओरिजिनल इज लॉस्ट, यू कैन से दैट ओरिजिनल कैन नॉट बी फाउंड और कैन नॉट बी प्रोड्यूस्ड विद इन अ रीजनेबल टाइम। सो ग्राउंड्स लगभग 65 वाले ही होंगे सेकेंडरी डॉक्यूमेंट के जो ग्राउंड है, फिर भी 65 डज नॉट नीड टू बी प्रूव्ड, because this document you are not producing as a piece of evidence, you are using it only for refreshing your memory. Then an expert may refresh his memory by reference to professional treaties. अब ऐसा ही आपने सेक्शन 60 में भी पढ़ा होगा, but there they are not refreshing your memories, but an expert, when he is giving some evidence, there are some books written by him or maybe by third person, so he can read the book into the court and then he can give the statement. So देखो, what you have to understand is what is refreshing of memory. आप एग्जामिनेशन इन चीफ के दौरान या क्रॉस के you are not able to recall the entire statement, then that document can be used by you to refresh your memory. You can use the original document or you can use the copy of that. Now copy if you use, then you have to take the permission from the court for that. And what is this document? Number one, it would have been written by the witness itself, or it have been written by a third person, written by himself, or it have been written by third person, but read by whom? When it is written by third person and read by whom? The witness himself. Read by the witness when his memory was fresh, and he revived that the document was correctly written. तो ये जो डॉक्यूमेंट लिखा गया या पढ़ा गया वो तब लिखा गया या पढ़ा हुआ होना चाहिए when the memory of the witness was fresh. अगर डॉक्यूमेंट किसी और ने लिखा था तो his memory was fresh plus he believes it to be correctly written, then he can refresh the memory. Is that fine? अब CRPC में पढ़ोगे, अब मान लो एक इन्वेस्टिगेटिंग ऑफिसर है, अब बेचारा इन्वेस्टिगेटिंग ऑफिसर तो कितने सारे केसेस इन्वेस्टिगेट करता है, उसको हर केस का हर डिटेल तो याद नहीं रहेगा। अब ही अपीयर्स इन द कोर्ट एज अ प्रोसिक्यूशन विटनेस, अब ही इज बीइंग एग्जामिन्ड एंड क्रॉस एग्जामिन्ड. अब इन द क्रॉस एग्जामिनेशन ही इज नॉट एबल टू रिकॉल द एंटायर स्टोरी because as a police officer he may have been involved in several cases, so every detail he did not remember. So can he use the case diary for refreshing his memory? The answer is yes, because the case diary was recorded by him when the incident took place, and therefore on the basis of case diary also he can refresh his memory. तो इसके लिए आपको प्रोविज़न मिलेगा 172 CRPC, so that I will be discussing later on. क्योंकि अगर उसने रिफ्रेश किया तो उसके बेसिस पर अपोजिट पार्टी को राइट मिल जाता है कि उसके बेसिस पर वो सवाल पूछ सके, तो दैट इज देयर इन CRPC. बट अदरवाइज जस्ट एन एग्जांपल, द इन्वेस्टिगेटिंग ऑफिसर आल्सो कैन रिफ्रेश हिज मेमोरी ऑन द बेसिस ऑफ केस डायरी. इज दैट फाइन? तो ये तो हो गया रिफ्रेशिंग ऑफ मेमोरी. अब आफ्टर द रिफ्रेशिंग द मेमोरी यू आर गिविंग द रिप्लाई. और ये चीज़ ध्यान रखना, मान लो ये डॉक्यूमेंट है It is not like this that you are reading it and replying it. Once you refreshed your memory, the document is taken away from you, and thereafter you will making a reply. Now let's see section 160. A witness may also testify to facts mentioned in any such document as is mentioned in section 159, although he has no specific recollection of the facts themselves, if he is sure that the facts were correctly recorded in the document. अब इसमें और 159 में फ़र्क ये है, फिर से पढ़ो. A witness may also testify. Testify means evidence to the facts mentioned in any such document as is mentioned in section 159. मतलब उसके खुद के लिखे डॉक्यूमेंट या किसी और का लिखा डॉक्यूमेंट 159 वाला, वैसे डॉक्यूमेंट के लिए दे आर सेइंग अ विटनेस मे ऑल्सो टेस्टिफाई मीन्स व्हाट, ही कैन डिक्लेयर दैट व्हाट इज रिटन इज करेक्टली रिटन although he has no specific recollection of the facts themselves, if he is sure that the facts were correctly recorded in the document. In this, if suppose a document is produced into the court as a piece of evidence, a witness is to be examined. A witness cannot recall the incident, so he can give the evidence in the court at least this much, that I remember. I am not able to recall the entire incident, but I do remember that when I had written this document, or when I had read this document, then my memory was fresh. When I read this document, when my memory was fresh, and I believe it to be correct. I believed it to be correctly written. तो इतना वो बयान दे सकता है, लेकिन ओरल एविडेंस उसका नहीं हो पाएगा क्योंकि उसको कुछ याद ही नहीं है. उसको कुछ याद नहीं है तो उसका ओरल एविडेंस नहीं हो पाएगा, लेकिन डॉक्यूमेंट के ट्रुथफुलनेस का बयान वो दे सकता है. सेक्शन 159 में आप डॉक्यूमेंट देखकर रिकॉल करके ओरल एविडेंस देते हो. 160 में आप डॉक्यूमेंट देखकर रिकॉल करके ओरल एविडेंस नहीं दे रहे, बल्कि डॉक्यूमेंट देखकर बस इतना कह रहे हो, इस डॉक्यूमेंट में जो कुछ लिखा है, आई रिमेंबर दैट इट वॉज करेक्टली रिटन. So that is the testimony to the fact that the document is correct. So is that fine? 159 you recall and give oral evidence after recalling, and in 160 you recall, sorry, in 160 you are not able to recall even if you see the document, but the only testimony you are giving is that this document is correctly recorded. The only testimony you are giving is that this document is correctly recorded. So that is fine. अब section 161 देखिए. 161 read. Any writing referred to under the provisions of the last two preceding sections must be produced and shown to the adverse party if he requires it. Such party may, if he pleases, cross-examine the witness thereupon. तो मान लो एक डॉक्यूमेंट है, उस डॉक्यूमेंट के बेसिस पे मैंने अपना मेमोरी रिकॉल किया और फिर अपना ओरल एविडेंस दिया, और या फिर 160 में मैंने ये कहा वॉट एवर इन दिस रिटन इज करेक्टली रिटन. So the moment I use this document to refresh my memory, either in 159 or 160, the moment I use this document, the opposite party gets the right to have a copy of that, and the opposite party on the basis of this can cross-examine me and also can contradict me under 145. 145 लिखा नहीं है, पर क्रॉस एग्जामिनेशन यू अंडरस्टैंड दैट कैन obviously be done on the basis of 145. So the moment witness refreshes his memory or gives the testimony under 160, the opposite party gets the right to have the copy of that document and cross-examine the witness on that basis and contradict also. So any writing referred to under the provisions of last two preceding sections must be produced and shown to the adverse party if he requires it. So adverse party अगर चाहे तो उसको आपको कॉपी देनी पड़ेगी, उसकी कॉपी देनी पड़ेगी. Such party may, if he pleases, cross-examine the witness thereupon. Such party may, if he pleases, cross-examine the witness thereupon. So is that fine? अब इसके बाद The remaining sections you read yourself. I am reading 167. 167, तो ये 162 वगैरह ये पढ़ लेना आप। अब 167 के अलावा और क्या करेंगे हम? 167, फिर 122 मे बी नेक्स्ट लेक्चर, देन 126, उसके अलावा 115 एंड 116. 117 I will not discuss because that is related to negotiable instrument and all, but 115 and 116 I will discuss. Now let's see 167. अब इसका भी बैकग्राउंड पहले समझा देता हूँ आपको. Now you are almost over with the Evidence Act, and I hope you appreciate now that there are certain evidence and certain facts which are admissible and certain evidences which are inadmissible. Now, if the evidence is admissible, then the court shall allow it, and if the evidence is inadmissible, then the court shall not allow it. What is inadmissible? The fact is irrelevant, or it is relevant but prohibited. So it is 25, 26, etc. मतलब वो एविडेंस जो किसी रेलिवेंट फैक्ट पे है वो एडमिसिबल होगा, और वो एविडेंस जो किसी रेलिवेंट फैक्ट पर नहीं है वो इनएडमिसिबल होगा, या फिर रेलिवेंट फैक्ट पर है लेकिन सेक्शन में डिक्लेयर्ड है कि इट शैल नॉट बी अलाउड टू बी प्रूव्ड, प्रोहिबिटेड. फॉर एग्जांपल सेक्शन 25, 26 एक्सेट्रा, privileged communication. So these are, even if they are relevant, they are not allowed to be proved, and if it is on relevant fact, then it is allowed to prove. If it is on relevant fact, then allowed to be proved. But one irrelevant fact, then it is allowed to be proved. Where? Section 155. 155 में impeaching the credit वाला जो केस है वो उस केस से रिलेवेंट फैक्ट से रिलेटेड नहीं है, लेकिन फिर भी उसका एविडेंस अलाउड होगा. इफ यू रिमेंबर आई टोल्ड यू अर्लियर, वो केस के रेलिवेंट फैक्ट से रिलेटेड नहीं है, वो विटनेस से रिलेटेड है, लेकिन फिर भी उसका क्रेडिट इम्पीच कर सकते हैं आप उस फैक्ट से. या फिर 148 वाले क्वेश्चन से याद करो. 148 में क्या था? द क्वेश्चन यू आर आस्किंग दैट इज नॉट रेलिवेंट इन द केस, बट दैट इज रेलिवेंट ओनली टू द एक्सटेंट ऑफ इंज्योरिंग द कैरेक्टर ऑफ द विटनेस. तो वो भी आपका इस लिस्ट में आएगा. और 165 में तो कोर्ट पूछता, अगर पार्टी नहीं पूछती. It can be relevant question or irrelevant. So what I am trying to tell you is simply that there are certain facts which are relevant, and if those facts are relevant, then the court will allow those facts to be proved unless it is declared not to be allowed. Unless it is declared not to be allowed. And there are certain facts to be irrelevant. On those facts, evidence will not be allowed. Upon those facts, evidence will not be allowed unless it is declared that it shall be allowed. 148, 155 एक्सेट्रा. और कोर्ट खुद तो 165 में रेलिवेंट फैक्ट पे सवाल पूछ ही सकता है. तो अब मान लो एक ट्रायल हुआ, देयर वाज अ ट्रायल. अब इन द ट्रायल कोर्ट रॉन्गली डिसअलाउड एविडेंस ऑन सम रेलिवेंट फैक्ट्स. कोर्ट ने रॉन्गली किसी रेलिवेंट फैक्ट पे एविडेंस को डिसअलाउ कर दिया. उसके बाद ट्रायल हुआ एंड द केस इज डिसाइडेड. अब द मैटर गोज इन अपील. द पार्टी अफेक्टेड गोज इन अपील एंड देयर ही रेजेस द ऑब्जेक्शन दैट द डिक्री शैल बी सेट असाइड बिकॉज ऑन द रेलिवेंट फैक्ट द एविडेंस वाज डिसअलाउड. Because on a relevant fact the evidence was disallowed means the court has wrongly disallowed the evidence. Court has wrongly disallowed that evidence, and therefore the decree shall be set aside. And in fact, in the appellate court he proves this fact that it was relevant, but still it was disallowed. अब the issue is, will the court simply because it is proved the evidence was not allowed on relevant fact, will the court set aside the decree per se? अब उसी तरीके से उल्टा भी समझ लो. The trial court allowed the evidence on irrelevant fact and the decree was passed. Then the party affected goes into the appeal, and then in appeal the party again raised the objection that an irrelevant fact was admitted by the court an irrelevant fact was admitted by the court. So now the point is that in appeal, will the appellate court, if it is proved that the fact was irrelevant, अगर ये prove हो जाए कि that fact was irrelevant, will the appellate court per se, will the appellate court per se, simply on the ground that the fact was irrelevant, set aside the degree? बताइए. So in either of these cases, the answer is no. Answer is no. तो एक का एग्जाम्पल ले रहा हूं मैं यहाँ पर. तो कोर्ट पर से डिग्री को सेट असाइड नहीं करेगा. कोर्ट ये एग्जामिन करेगा कि अगर वो इररेलेवेंट फैक्ट अलाउड नहीं होता तो क्या केस का जजमेंट डिफरेंट हो जाता. देन द कोर्ट विल एग्जामिन दैट हाउ मटेरियल दैट फैक्ट वाज इन द डिसीजन ऑफ द केस. अगर मान लो हमने वो इररेलेवेंट फैक्ट अलाउ नहीं किया होता तो क्या ट्रायल कोर्ट के जजमेंट के मेरिट्स पर कोई इफेक्ट होता. क्या उसका जजमेंट डिफरेंट हो जाता. तो अगर कोर्ट को लगता है, अपलेट कोर्ट को, दैट द जजमेंट वुड हैव बीन डिफरेंट बिकॉज दैट फैक्ट वाज वेरी इंपॉर्टेंट एंड रॉन्गली अलाउड, then in that case the court will set aside the judgment. Similarly, in the earlier example, if you had disallowed a relevant fact, इससे पहले वाला example, ये वाला, if you have disallowed a relevant fact, if you have disallowed an evidence on relevant fact, then in that case the appellate court will examine that if that evidence was allowed, जिस evidence को हमने disallow किया है, अगर उसी एविडेंस को अलाउ कर दिया गया होता तो वुड दैट हैव अफेक्ट द डिसीजन ऑफ द केस, वुड दैट हैव रिवर्स द डिसीजन ऑफ द केस. इफ यस, तो मतलब कहने का मतलब ये है कि जो गलती की है कोर्ट ने, अगर वो गलती नहीं की होती ट्रायल कोर्ट ने, तो वो फिर इतना मटेरियल फैक्ट था तो उसकी वजह से केस का जजमेंट बदल जाता. तब फिर द अपीलेट कोर्ट विल सेट असाइड द डिग्री. So the court will examine the appellate court that the mistake that the trial court has committed was that mistake on the fact was so material that if the mistake not had been committed, the judgment of the trial court will have been different. Means it will materially affected the merits of the case. Means what? That fact is very important. So if allowed, then also it should not be allowed, and if it is not allowed, then it should be allowed. It was so material. Then in that case the appellate court will set aside the degree. So is that fine? तो अब पढ़ो सेक्शन 167 पढ़ते हैं. The improper admission what? Irrelevant fact is allowed to be proved, or the rejection of the evidence means relevant fact was not allowed to be proved. The improper admission or the rejection of evidence shall not be ground of itself for a new trial or reversal of any decision in the case. तो वो सीधा कह रहे हैं कि सिर्फ इस वजह से, only because an irrelevant fact is allowed to be proved or a relevant fact is not allowed to be proved, per se will not be a ground for setting aside the decree and conducting a new trial or reversal of any decision in any case, if it shall appear to the court before which such objection is raised that independently of the evidence objected to and admitted, there was sufficient evidence to justify the decision, or that if the rejected evidence had been received, it ought not to have varied the decision. तो ये उल्टा लिख रहे हैं, if it shall appear to the court before which such objection is raised. Before such objection is raised मतलब क्या है, appellate court या revisional court. Before which such objection is raised that independently of the evidence objected to and admitted. मतलब वो irrelevant fact था जिसको आपने एडमिट कर दिया था और उसको हटा देने के बाद भी there was sufficient evidence to justify the decision. मतलब उस irrelevant fact को हटा भी दो तब भी the decision will not alter. The other evidence will result into the same decision. या फिर they are saying or that if the rejected evidence relevant fact had been received, had been allowed, it ought not to have varied the decision, then in that case the court will not set aside the decree. वैसे भी ये implied है कि when will the court will set aside the decree? When the rejected evidence, if allowed, will alter the decision, or when the accepted evidence, if not allowed, would have altered the decision. So it was such a material defect, then only the decree will be set aside, otherwise not. So is that fine? तो इस पर लिख लीजिए थोड़ा. And you must remember that this is the last section of the Evidence Act, and being at this stage I hope that everything was understood. Right? If the trial court has disallowed evidence on a relevant fact or has allowed evidence on a irrelevant fact, then the decision of the trial court merely on that ground will not be set aside by the appellate court. Rather, the party concerned will have to prove that the defect was so material that the merits of the case would have got affected and the decision would have been different if the defect had not been there. That is, if the wrongly admitted evidence was not admitted or the wrongly rejected evidence had been admitted, then the decision of the case would have been different. Then only the appellate or revisional court set aside the decree or order on that ground. So decree के बाद तो appellate court में जाएंगे, order के बाद revision में जाएंगे. So then only the appellate or revisional court set aside the decree on that ground. So that's it for this section and this lecture also. Thank you.